Good afternoon, everyone. Welcome to the January 9th, 2020 Industrialized Building Code Council meeting. If there's anyone here that wants to do a public comment, we have one already. The forms are up at the front table. At this point in time, I'd like to call order. Randy Childers, here. Suzanne Arnold,
Here.
Brian Bailey, Janet Hoffman,
Here.
Robert Lesu, Edward Martin,
Here.
Scott McDonald,
Present.
Marcella Rhodes, Douglas Robinson,
Here.
Stephen Shang,
Here.
Dub Smith.
Here.
I believe with that we have a quorum. Great. I would like to move on to item C, approval of minutes from the June 20th meeting. I'm hoping everyone has read the meeting minutes. Do I have a motion to approve?
Motion?
Second. Second.
Okay, who, Janet? You
Yes.
Motion, who's second?
Scott.
Scott? Okay, we have a second. All in favor, say aye.
Aye.
Any opposed? Okay, we're good. Item D, I've already discussed about public comment. If anyone wants to make a public comment, get your forms ready. We'll get to that later on in the discussion. At this point in time, we move on to item E, staff reports, starting with the licensing division.
Good afternoon, Chairman Brown and board members. Happy New Year, and it's good to see you this afternoon. My name is Chloe Whalen, Licensing Manager for this program. You are being handed out a corrected copy of my statistics report. I noticed a mistake on it this morning, so I had to get that corrected for you guys and get you a new copy. While you're reviewing those statistics, I have just a couple of updates. I have the opportunity and pleasure of hiring two new people. One is already hired. She's a former TDLR employee. Her name is Irma Mendoza, and we are glad that she is back and on our team. The other I wanted to just mention to the industry and those that are going to be potential applicants to register, to make sure that they answer the criminal history question on the second page. We've gotten some applications where they missed that particular question, so we have to send it back and let them get that, have them answer that question and then send it back to us. And that's all I have, unless you have questions regarding the statistics report.
Council, any questions? Chloe, thank you very much.
You're welcome.
I believe we go to Customer Service Division next.
Good afternoon, advisory board members. My name is Tuan Nguyen. I'm one of the customer service managers for this program. Since the last time we met, the average amount of phone calls coming in for this program has still been pretty average, roughly about 32, 35-ish. And again, most of our customers are calling in about website navigation. We did get a couple of calls about application statuses, which we helped direct to our licensing department, and a couple of questions requiring about requirements, which we did send to our RPM team. Other than that, I'll be happy to answer any questions you have for me.
Any questions from council? You got off easy. Thank you
Thanks.
very much. The Enforcement Division.
Good afternoon, Chairman and Council members. My name is Morgan Cumming. I'm a prosecutor with the Enforcement Division, and I will present today the Enforcement Division staff report, which is on page 6 of your documents, or it was when I did this presentation, but I think they've added documents since then, so it may have moved the page. During our last meeting, I discussed with you all the statistics for fiscal years 2018 and 2019, which are in the report. Today, I will focus on the statistics derived from the Division's regulatory actions for fiscal year 2020 to provide you with a general overview of enforcement's activities. 3 cases have been opened in fiscal year 2020, which began on September 1st, 2019. 11 cases have been closed without any final orders being issued or any penalties being assessed. You also received a pie chart. It was going to be a handout, but they managed to put it in your documents with the sources of complaints, sources of cases, sorry, being consumer and departmental. You had asked for this previously and during the June meeting, and we provided it during the non-quorum meeting past year. So I again included it in your materials. However, I need to know if this is something you want to be a permanent report in your enforcement report, or is this sufficient on its own for this one time today?
Sure.
Yes.
I appreciate it. I think it's of value. I'm curious, and maybe I missed it in the backup, how many cases are currently open?
Total that are currently open, right now, I did not look that up because I don't, right, we've only opened 3 cases in 2020, and there was, in fiscal year 2019, there was 23 cases, but I don't know how many open right now, but I can look that up for you and get that to you later.
Okay, I just think that would be useful, at least to kind of try to manage. We see how many are opened each year and how many are closed, but then again, those ongoing aren't necessarily represented. Thinking in terms as we look at the.
Mary Winston, TDLR. Mr. McDonald, that is a good indicator that we can do, because just saying 3, we do know that we don't have a large number, but to kind of do a comparative, a couple of years, to kind of just give us that. We can do that, and we can provide that to to all of you individually and kind of make that part of the report.
Great, thank you.
Mm-hmm.
Any thoughts on the pie chart one?
Oh, I'm sorry. Oh, Mary Winston again, I'm sorry. I'm getting beeped from folks sitting back there. Thank you, John Medlock. There are 17 total cases open now.
Very good, thank you.
Uh-huh.
I think it's useful, the pie chart.
Okay, so you want it to be a permanent fixture.
One personal opinion.
The rest of the council? Is this a yes?
Yes.
Okay. Do you have any other questions?
I do have a question. This is Roland Brown. Under the sources of cases open through November of fiscal year 2020, we've got consumer, and then we have criminal history.
Mm-hmm.
What does criminal history mean in this case?
When either applicant or licensee renews, they have to do a criminal history background check. And so 33 cases were opened based on criminal history results, either in an application or a renewal. Somebody had a conviction. So a case was opened based on that criminal history.
So how is that important to council? It may be important to your department, but is that something that would be considered value for us?
Well, you asked for the sources
Okay,
of the cases, and so in order to do a pie chart, you can't just selectively omit something because,
I understand.
so that was the source of that case.
I see.
So it might be interested to y'all to know that there are people in your industry that do have criminal history convictions.
So may I ask a question?
Yes.
This is Eddie Martin. To clarify, so if someone is reapplying and they have a criminal history, you automatically open the case, to investigate it?
Not necessarily. There's 2 criminal history attorneys that are devoted to those type of cases. And if it's like, say, they get convicted of a Class C misdemeanor, which in essence is a speeding ticket, but it can be other things as well. They probably won't open a case based on that criminal history conviction. So most likely cases get opened when we get a criminal history ding, so to speak, somebody has been convicted, based on the type of conviction would be within our conviction enforcement plan, would have been something that we need to investigate further because it could impact whether they can or cannot have a license.
So Eddie Martin again. So you're opening it, though, to determine whether you want to reissue the license.
Whether they're eligible to
Okay.
maintain or keep the license
Yeah.
or be issued a license at all.
Okay. Thank you.
Chairman, Doug Smith. Are these, obviously, these might be a DWI or a pending case, so it.
No, it's a conviction.
It has to be a conviction.
It has to be a conviction.
And
It's not
just a
it's not an
charge
arrest,
and
and
settled.
it's not an arrest or an indictment, it's an actual conviction.
I know there was an issue with the appraisal licensing board and track that they had an issue of people that had dismissed cases, but because on the form you have to put, have you ever been charged? It was holding up a whole bunch of licenses. So we're not doing that.
They could have been placed on deferred adjudication,
Right.
but it has to actually be a final resolution, a conviction or deferred adjudication.
And even that may or may not cause us to not license them.
Right, but they have to open the case to give the applicant or the renew person an opportunity to give their side of the story about what happened. And so we wouldn't just unilaterally deny it because they got convicted. We open a case to allow them to provide why they got convicted and if there's any mitigating evidence or actions they've taken to give us discretion to grant or not grant the license, like rehabilitation.
Chairman Benson, one more question. Are we doing fingerprinting in the background check?
For this program,
I know I have to for track and.
yeah,
for licensing
for
board
certain
and-
licenses, that is true. I'm not sure about IHB.
Not for, Mary Winston, not for this program, but something I do see, Morgan, possibly, because we do presentations, each of the divisions, on kind of how things work, and enforcement is always an interesting one, even though this program has little enforcement, not a lot of complaints at all. I think, you know, we're not at that point yet, but maybe we can have in our report an update. So the whole council for different questions that are kind of popping up, so we can kind of answer some things that we would just want to know our process. Because Mr. Smith, I've actually worked at the Real Estate Commission as a prosecutor before, and every agency's just a little different, depending on how the law to that specific profession reads.
Any more questions? Well, thank y'all.
Maureen, thank you very much. Moving on to item 4, Regulatory Program Management Division.
Good afternoon. I'm Donna Lipke, Program Manager for Industrialized Housing and Buildings. Basically, this hasn't changed much from the last meeting that didn't happen. And you guys who weren't here last time missed the enforcement question and answer presentation that was done. I don't know if that's been recorded or not, if the other people can see it that are on the council, but you might want to go back and look at it if it is. So I'm going to do a personnel update again. We have a new program specialist, Wallace Britton. He's formerly building official from City of Fredericksburg. He's also worked as basically a third-party inspector for different companies, and I think he's worked for the City of Austin also, if I'm remembering correctly. Also, Catherine Vaughn is retiring at the end of this month, so. Let's see. Okay. This is a list of manufacturers that have been certified since the last official council meeting. There's no certification date in there for Falcon Structures. Today is that date, so they completed everything as of today.
Through the chair, Randy Childers, Stephen, what took you so long?
Sorry. We'll be faster next time, I promise.
So, I was pretty sure they were going to be finished by today, so that's why I put it in there, so.
I do appreciate the check.
So these are projects that we currently have going on, certifications. I'm not sure why Dunn Group's in there. Dunn Group shouldn't be in there. They're complete. Oh, this is a continuation, that's right, because because we didn't have a meeting like we were supposed to last time, this report is 2 pages long. So these are more manufacturers that have been certified since the last official meeting of the council. We've been very busy, so. The next page shows certification inspections that are currently in process, or that will be started soon. We have one starting next week that is not here. They weren't on the schedule at the time I did this. What is it, Chris? Chillicothe. And just so you know that Brian Ledbetter is now registered as a third-party site inspector, and we're using him to help us with some of these inspections, so he'll be doing that inspection. So for those of you who haven't been on the council for a while, he was a program specialist that worked for this program, and he moved to Vermont, so.
Mr. Chairman, this is Mike Ersman, as Deputy Executive Director. We've received notice from the management of the property that there is a white Chrysler that's parked in the lot, license plate LSC 5322. If that belongs to anybody here, I think it's on right now, and there's nobody in there. So I don't know if
Wow.
I know my vehicle's black, so I could have done that, but it wasn't me. So I just want to make sure no one else did that.
Nope, not me.
Sorry, Donna, go ahead.
That's okay. Okay, this is, we did 100% inspection for KW Custom Controls in Indiana. They are also going to get certified, but they had a deadline they wanted to meet, they needed to meet, so we, since we couldn't get them on our schedule, we allowed them to get 100% inspection. Currently, we don't have any consumer complaint inspections to perform. There haven't been as many. I know there's not as a lot of enforcement complaints for the IHB program, but usually when they're consumer complaints, they're very, very detailed. There's a lot to look at, and the reports are kind of quite complicated. So I'm just glad we don't have any to do right now, because it takes time away from other stuff. So, and these are reasons why these manufacturers may have had, start dates for certifications that were in last year and they're not completed yet. There's follow-up required or plans that need to be revised, things like that. Or sometimes we're just waiting for inspections to be paid for, so. Okay, this is a breakdown of the number of modular units that have been constructed in fiscal years. As a reminder, our fiscal year starts September 1st and goes through August 31st. As you can see, the number of total units constructed for fiscal year 19 is up quite a bit from the previous years. I know it doesn't look like there's a lot of modular components right now, but we've been having a lot of inspections on those, so that's going to increase.
Yes, yeah.
Back up on the other slide, it says first unit too far along to fully witness some areas of construction and compliance control procedures in full. How do you resolve that?
Usually, we end up doing a 100% inspection board. We have them take panels off and look at things, and if things aren't right, they'll have to deconstruct it more. And so, but that unit is not used for certification. They have to build another unit for certification that we see through all procedures, so. I'm sure that happens on site too, with people starting construction before they have a permit. So.
Through the chair, in Waco, never.
Never.
Never happens. I do have a question for you, Donna. Because we look at some of these time periods and they appear to be kind of long, so is it incumbent upon the manufacturer to, say 3 months goes by, if you haven't heard, do y'all have a tickler list, or is it just incumbent upon them to get back with you? Or you call Randy and say, why haven't you submitted X for our review? Or is it totally
It depends on the manufacturer. We do have a thing in our procedures that they're supposed to complete things within 6 months. And if they want to go past that, they're supposed to let us know. A lot of times we will contact them to make sure they still want to proceed. So, and sometimes these buildings are really complex and it takes a while to construct them also. Okay, as I said, total modular units constructed by use. I think you can see equipment shelters has increased quite a bit from previous years. It's still going up too, so. Where's the mouse? Oops. Did I miss a page? Okay, no, that's right. This is just a chart showing the types of units constructed. The office is the largest number, and modular components is the next largest, and then it's equipment buildings. So. This first table just shows the number of units that we've been reported to as completed but haven't been released yet. Oops, there we go. And that's through October 2019. This is the number of inspections by third parties. Something's wrong there. I don't know what happened. These numbers are not right. I'm going to have to go look and see what happened here. These should not be equal to the fiscal year 2019. Somehow that didn't get changed. But inspections are up. So.
Donna, this is Roland. Under equipment shelters, does that combine both the building of the shelter or the structure itself and then the integrator process for those type of buildings that are going down that path?
It could be both, yeah. It's, yeah. For certifications, it definitely is. For number of equipment shelters, no, it doesn't, for the total number constructed.
So looking at total modular unit constructed by use, that is just the shell?
That's the entire building.
That's the entire completed?
Completed building, yeah. Because it only gets an insignia. So it might be counted in the modular component, the shell. Mm-hmm. But then it would be counted as a completed building under the decals, under units labeled with a decal.
So if I look at the number for fiscal year 20 at 259, that just means there's 259
modular sections.
Modular sections.
Yeah.
And some of them may be complete. Some of them are yet to go to an integrator to get those.
No, those are ones completed. If it's in that table, total modular units,
okay,
it's the number completed that have shipped. It's gone from the integrator already.
okay.
So.
Thank you.
And Donna, on the facilities inspected, is that full factory inspections, meaning like there were 1,157 factories that were actually
Right,
inspected?
right. And then there was 7,815 sections.
Are there that many factories in the program?
No.
Okay. So maybe one factory might have 5 or 6 inspections.
Yeah, some inspections, some manufacturers have their units inspected more than once too. So it's just actually the total number of units that have been inspected. At least the decal sales are correct for fiscal year 20. So again, this is through December 16th, 2019. That's when I took the snapshot of our database. So as you can see, it's the sales for decals has increased. We expect it to increase more this year too. So this again shows the total sales. I tried to break it down by type of building. Industrialized housing is the smallest bar. Equipment shelters is the next bar, and then other commercial buildings is the greatest amount. That includes equipment buildings, that other commercial. Actually, no, it doesn't. Sorry. That's just everything but equipment buildings. So. These are total decals sold. The number of sold, again, those numbers are going up. Like I said, we've been really busy with certification inspections, so I expect that to keep going up. We're getting more component manufacturers also. Same sort of thing with the chart. Other commercial is the largest amount that we have. Insignia sales, as you can see, the insignia sales went way up in fiscal year 19. Again, this is through October 2019, and we expect that to increase. That's only, October 2019 is only 1 month into the fiscal year, so. And this shows the total number of insignia sold. Again, it's only 1 month into the fiscal year. And that's all I have.
Any additional questions of Donna? Council? Donna, thank you very much. You're good.
I'm up to the next one.
Oh, you get to do that too.
Yeah.
Executive office.
Oh,
yours.
executive office, I forgot, yeah.
Mr.
I was
Chairman,
looking at
this is-
E.
Mr. Chairman, this is Mike Arismenis with the executive summary. I'm the Deputy Executive Director for the agency. I want to thank you for being here. I know that last time we met, we didn't have a quorum, but I think you still received some information, so I do appreciate you coming and attending. As far as personal updates, there's not much to tell you. I believe that the last meeting we had, we let you know that your one and only David Gonzalez is now a Deputy Executive Director with the agency. He was promoted beginning December 1, so we do want to congratulate him, as long with Christina Kaiser, who was the Director of Enforcement, is now a Deputy Executive Director as well. So Carla James had retired, so in that spot, we ended up bringing up David and Christina to be able to help. As our agency begins to expand, we have additional programs that are being brought over, which means that there's just additional responsibilities that have to be taken, and just the bulk of it in itself. So we now have a lot of things that are going on. So one of the other thing is that we are still in sunset. I believe we told you the last time that we're in the sunset process. A couple of things that you need to know about the sunset process is that, first of all, it's still going on. It has been a ongoing meetings after meetings after meetings. I believe at this point in time, we've had about 27 meetings with Sunset, and we have 13 more scheduled. You should have already received an email from our listserv, basically stating if you've got any questions, if you got any concerns, praises, anything that you'd like to say about the agency, you have the ability to do that through the Sunset Commission and through the website portal. If you go to our website at tdlr.texas.gov, at the very main page, above the fold, is a link for you to be able to get directly to Sunset and be able to provide comments back. What will happen is that in July, I believe, they're going to have some open public hearings. So be able to make comments in a public hearing format as well. So they'll take public comment in a commission setting. So we do invite all of our industries, all of our licensees to come out and be able to provide input for TDLR. It gives us the opportunity to be able to learn. It gives the opportunity to be able to expand what we do and to find our pain points and be able to correct those pain points. So it's a great process for us to be able to do that with. I would tell you a couple of things, is that on the communication outreach, pretty amazing. Since July July 1 of 2019 until the end of the year, December 31, there were 29,236 hits on the IHB website, off of our TDLR website. So that's an average of about 159 per day. So there's quite a bit of traffic going through there. Somehow or another, they're able to tell us that 73% of those visiting accessed it from a desktop computer, 23% did it from a smartphone, and 4% from a tablet. So I don't know how they do it, but they do. These could be numbers that they want me to give you to make me look foolish, but they still give it to me, so I pass it on. We have some top reasons that they visit the website. The number 5 reason is mandatory building codes. The number 4 reason is frequently asked questions. And the number 3 reason are administrative rules. The number 2 reason are the forms. And then the number 1 reason that they visit the website is for registered lists, so to the IHB. So it's very interesting statistics that we have. Our top-notch crack web administrator, Josh Schneider, can actually provide all this information for us, which he does. Without him, I don't know where I would be as far as the website's concerned. But I want you to know that we are continuing to have a lot of traffic going through the IHB website. So there's a lot of interested parties trying to find out more about IHB. So it is one of our heavily trafficked areas that we have. So I'll be happy to answer any question that you have, or if you want to give congratulatories to David, feel free to do so.
Mr. Chair, I just wanted to acknowledge the appointees, and I appreciate, their advancement within the organization. I think it'll be a benefit.
Agreed. And also as well, I have, somebody just gave me a comment. Comments closed January 1 for Sunset. So now the next time would be the public hearing portion of it. So I want to thank Mary Winston for providing information. We have the ability to kind of talk back and forth. So as Mary received information from a top-notch Red Raider back there with John Medlock, he's a fellow Texas Tech Red Raider, which, we all want to get our guns up for that. We also are able to provide information back and forth. I see you disappointed there, Mr. Childers.
I like honest glass.
Yeah.
David Gonzalez, TR, just to make sure the point is clear, there's still opportunities to provide input
There is.
to the Sunset Commission. It's just not going to be confidential anymore where it's part of their review and the Sunset staff. It would be on the record now and in regards to any reports they put out. So you still have the opportunity to provide candid information. We need the input again. So thank you. There is going to be more opportunities.
If I can add to that, Steve and Shang and I had a very good, Steve met in person, I by phone, probably an hour-long conversation with the Sunset Commission.
Oh, good. Good. Excellent.
And
Excellent.
you
That's
can
good to
assume
know.
it was a good, positive conversation, so.
Well, we appreciate that.
It was
Thank you very
enjoyable.
much.
Very much so.
I'm available for any questions if you have any.
Thank you, Mike.
Thank you.
Donna, moving on to F.
Okay, discussion on current and possible future IHB educational and outreach activities. At the last official meeting, you asked for a discussion about that. I just want to bring up too that we now have an IHB Tech email address that I was looking at how many emails we address each month because we archive them by the month we take care of it. And for the month of December, there were a total of 300 emails that were answered. That includes the responses to the emails, but and that's one way we provide education to the industry is when they ask questions, we're there to address them in writing, and if they need us to call them back, we do that also. We're also currently updating our FAQs to make them more relevant, especially with equipment buildings and integrators. Each certification inspection we do basically is an educational opportunity also for the manufacturers that are new to the Texas program. So they learn quite a bit about our program at that time. We're also interested in any other types of outreach you would like to see the department do. So it's open for discussion.
Council?
I think, Chairman Rowland. So I think, having been around Texas for the last couple of years, talking to the BPI and different code official type meetings that are out there, I think there is an opportunity to provide some type of content to these forums. A lot of the building code officials that are more local have questions about how the modular program works, how it interfaces with their local programs and all that. And I think if council, if y'all have the time to provide council with like a canned presentation that's maybe 20 or 30 slides that goes on for about 40, 50 minutes, I think these groups would be welcoming of such a presentation. Now, whether or not you guys want to give the presentation or you want to tap some people in the council to give the presentation, I think it would be well received, and I think it would be very educational throughout the state. I mean, you've organized some of these things.
I agree.
Yeah.
Okay. Any other recommendations?
Sure. I
Yes,
might piggyback
Scott.
on that, and in fact, if you were thinking to do that, if in fact, and David can probably shed some light on BPI, the Building Professional Institute in Arlington may be a good source to get to local government.
Yeah, I think George and David have approached them before about that, and they've never really shown an interest that I'm aware of.
David Gonzalez. So we have done presentations there. Most of the time when we attend BPI, we're in attendance to actually learn things. But there could be opportunities. Remember,
Yeah.
they've had leadership changes. There could be opportunities to bring it up
But
again.
I think George Ferry has brought it up in the past, but yeah, we could bring it up again.
That's right. There may be another opportunity because they've got new leadership, different interests, different requirements out there. There might be an opportunity to approach it again.
David, happy to help if I need to.
I think that's a very good suggestion. The Building Professional Institute's a very strong program in Texas, so it's a great idea. Donna, anything else? Council, any other questions of Donna while she's there? Donna, thank you very much. Donna, are we moving on to H? Is it part of yours too, I assume?
To G, discussion and possible recommendation to start process of adopting later code
Oh, yeah.
editions.
I
So,
like to skip that one for some reason.
so would I, but we don't want to wait until the 2021 codes are out. We kind of like to get the 2018 adopted, so we're not skipping a code. Also, we're kind of behind on the NEC. I think the electrical board just approved rules to propose the adoption of the, is it the 2020 NEC?
2020.
2020 NEC. So, David, do you know what the effective date of that is?
I'm sorry?
Do you know what the effective date of the 2020 NEC will be for the electrical program?
It's scheduled for September 1st. We missed it the last go-around and missed it by about 2 weeks because of a quorum issue that we had, but it is on schedule to be September 1st of next year, and we would hope they would continue that way every 3 years into perpetuity. But sometimes things go beyond our control. There does have to be a quorum of the commission in order to pass it.
So,
David, you mean September 1st this year?
This year, 2020.
I think you said next year.
I'm so sorry.
We're in
still in last
2020,
year.
right?
I'm still in last
Just
year.
double checking. Okay, 2020.
Short timers.
so we would be we're in the 2014 right now, so we'd be skipping edition of the NEC, but I think we need to get caught up to where the NEC is currently.
And Donna, this is Roland. Take council through the steps that are required by us and the time it's required to notify builders and manufacturers for a new code addition to be accepted in Texas.
Okay, so once an effective date is determined, we have to give the industry 180-day notice of that. So there are rules that have to be proposed, brought to you, any amendments to the codes that we want to do. Usually the amendments we do are just administrative type things. So we have to bring all that into you guys to approve the proposal. Then if there's any comments that are relevant that aren't other than, grammatical errors or something like that, we would bring those back to the council. And the council would determine the effective date they want. It would have to be 180 days from that. It could be 180 days from that meeting, or, say you wanted to, the meeting was in, I don't know. I think last time we did more than 180 days because we wanted it to start on the beginning of the month. So, but it has to be at least 180 days. But the rulemaking process takes some time also. I will defer to Molly for that.
Hello, Molly Fudel, Assistant General Counsel. So anytime we do any sort of rulemaking, and the code change will be done as part of a rulemaking, we have to assess the fiscal impact on various folks, and that takes some time. We have to write up the rules. We bring them to you. We publish them in the Texas Register, and there's that 30-day comment period. And then we have to have a little bit of time to review the comments and bring them back to you. And you would then look at the comments, look at the rules, we're going to be doing that in a little bit, and make a recommendation to the commission, and then the commission would vote on them. So that takes some time.
So the action we need to take today is just to make a motion that we want to start the path. Start
Basically,
moving.
yeah. And I'm not even sure if you need a motion. If you just want us to get started on everything, we can do that. Do we need a motion?
We're open for discussion, even if we don't have to have a motion. Any discussion
Should we-
relative to this?
Mr. Chairman,
Should we do a
Yes,
motion?
Doug?
Doug Robinson. Noah, would you take it one step further in, for new commissioners or the audience? Code, we don't debate what codes to adopt. Those are specified to us by the state legislature, right?
It's basically in our law, it specified the codes produced by ICBO and SBCCI, but those now are combined into ICC, so it's the ICC codes that we go with now, and the NEC. We can't, there's nothing in our law that allows us to say, do the uniform plumbing code or uniform mechanical code.
But as far as timing, we are to adopt the most recent,
It's up to the council.
it is up to the council. It's
Yeah.
not part of the legislation.
No, except for the energy code.
Okay.
And the agency would like us to be up to date with the NEC also. But the energy code, the next time they can adopt that, I think, is 2022. I think that's 6 years from the last one. 2016, yeah.
Don't we have to adopt what the state has adopted? So-
The state the last code adopted by the state, I'm not sure what edition it was.
Mr. Chair.
Yes, Scott.
So a couple of pieces to it. The 2015 Energy Code is the
Right.
code for the state. So as long as we meet those minimum standards, we're okay, and we can be more stringent than, so that's later editions of the code are considered more stringent than, so we can propose those changes. The state of Texas, for the most part by default, takes the NEC and adopts the most current edition as the state electric code. So going to the 2017, then would be the 2020. And then the I-codes are on 3-year cycles, so we would be proposing to talk about the 2018 code.
yeah.
And I guess my only thought is it may be useful to have an understanding of the difference between the code that we're under and the 2018, and maybe through that time frame that we may be considering that the 2021s would be out, that we may look at what the 2018s are and then maybe just go to the 2021 code. Because I think in the timing of this, that making the assumption the international codes would be published in advance of January 2021, that is when the 2021 code could be in effect.
But I don't think the state can adopt the 2021 energy code until 2022.
And that may be the case, but
Yeah.
speaking in terms of building residential and the associated codes, just for a sense of consistency, or maybe not having to go back through the process. If in fact we're in 2020, it's gonna take us close to a year, if not longer, to go through the code process. I think to explore the 2018, have a good understanding of the changes of the current code to the 2018. At that time, then we'll also get the proposed changes to the 2021 codes, maybe a wiser path. It just wouldn't take that much longer, and we'd be on the most current code then at that time.
Is Hamid Naderi still the ICC representative here in Texas?
Well, he's one of.
Because I was just thinking maybe we could get him to make a presentation at the next meeting and show what the differences are.
Yeah, and we certainly can get a hold of some individuals that might be able to speak to that. So we have a governmental rep as well as.
Yeah, and I was thinking of him because he's local. He's here in Austin, so.
Through the chair, Randy Childers. Scott, are the significant change documents that ICC produces, do those even exist for the 2021 yet?
No.
From the 2018?
No. 2018, yes.
Yes, 2018, yes.
2018, yes, 2021, not as of yet.
Yeah, that would be one of my concerns. What direction will they go with the ASCE 7, whatever it will be relative to 2021? Personal opinion, I don't like jumping because that you start missing stuff if you jump. I'm open to it, I honestly am, but I'd want to enter into it cautiously. I've got, minimal experience with anything beyond 2015 right now. So
And that was my suggestion as far as that we start exploring with the 2018, get a good grasp between the differences of what code that we're currently under and the 2018 edition of the code. And then it would be much simpler to look at the significant changes, because that's where the focus goes first, the significant changes between the 2018 and the 2021. And then that way we would explore, but we would have the work done for the 2018 if in fact that then this council elects to go to the 2018 and to delay on the 2021. But inevitably, we would be going back through the process again. So not knowing what standards would be aligned with that code, which to Donna's point, ICC could tell us at this point in time what standards, because for the most part, the code development process is fairly complete.
Right.
So the codes are typically 3 years behind, and they're working on the next edition.
And the driver in recent years has been the energy code, right?
Yes.
And the state law relative to the State Energy Conservation Office. I know that the last time or the last two times, that's kind of put us in gear to adopt.
Right, and SECO can't adopt another energy code until 2022. They have to wait 6 years. So basically,
Right.
they're going to be, probably going to be skipping a code.
And Donna, do you recall, is that for residential only, is that for residential and commercial?
I think that's for both.
It's for both.
I didn't recall that. But
It was for both.
Yeah.
So it sounds as though we really should not go to 2021 until the State Energy Conservation Office says we have to move to the what is it?
Yeah, I don't know when they'll begin the process. They have to have the Texas Energy Lab do a review of the codes and make a recommendation to SECO, and then SECO will determine from then what they're going to do.
Mr. Chair?
Yes, sir. Yes, Scott.
Just the only concern that I have, the energy provisions are probably the most costly of any of the code changes, or they traditionally have been. But the changes in building technology and the advances, sometimes we can find ourselves behind the 8 ball. And so I do support the fact of looking at the 2018s and at least going down that path of starting the process, not suggesting that we're just going to skip the 2018. So I don't want us to get too far ahead of ourselves to say that we're just automatically going to skip, but going through the process, if it's going to take us that long, that we might also just go with that consideration that may want to look at just the 2021 as well. I think often there are some things that are lost within the code development process or adoption of a more current code, is that there is also benefit to the manufacturer, the builder, where there are advances in building technology where new products are allowed to be used, or other products are not necessarily prohibited, and even lessened because the building safety is enhanced with each version of the code. So I just want to go in with open eyes and make sure that if we have an opportunity, rather than going through a process of setting builders up in a place that they're going to go to one code and then we're going to come back a year later and change codes one more time. I think that has an expense and a problem.
Yeah, I can respect that. Being on the industry side of it, one of the concerns that we always have is each time there's a code change, in recent years driven by the energy code more than any other aspects, there is a big cost jump. And for those of us who have certain products that are more to a commodity, if you will, to the marketplace, and suddenly you're talking to a school, for example, and they go, oh, wow, why in the world did this building just jump $12,000 in price? We're buying the same building that we bought last year. And so sometimes whenever, not in all cases, but sometimes whenever you're jumping a code, if you will, you're compounding that. And that's one of the reasons I asked the questions about the Energy Conservation Code or the International Energy Conservation Code from the standpoint of how big of a jump are we going to be taking. It sounds like we're not going to be pushed down to that to sometimes in 2022, correct?
Yeah.
So I would tend to think, I'd like to hope, that the impact relative to the other areas of the code would be minimal from a cost standpoint, but not knowing what's in it yet, I'm afraid to say. So my default answer relative to industry is let's just not jump, because it could cause a cost increase to the marketplace that's kind of a shock to the customer.
Don't disagree.
Okay.
Council, any other comments or questions?
Through the chair.
Yes, sir.
Randy Childers. The other thing, Donna, is that date for SECO. I think there was some confusion that municipalities could not adopt the 2018, but that 2021 date is for SECO, not for cities. So I know Waco and a bunch of cities in the Metroplex
Right.
are fixing to adopt the 2018 energy code. There was a thought that cities couldn't do that, but that 2021 only is applied to SECO, not to
Right.
municipalities.
Right.
And even though a building could be, through this program, could be produced with the 2015, because it went through this process, I don't think there'd be any issue that Waco or any other city that adopted the 2018 shouldn't be a problem if a structure or a building is built to the 2015, because it meets the criteria in effect for this program. So I don't think, and the other thing is, I don't think Scott is talking about skipping the 2018, because one of the difficulties, we did that once several years ago, and there won't be any significant change documents from the 2015 to the 2021. They
Right.
don't usually do.
And we had
They
that.
don't anticipate you skipping, so you won't be, so you almost have to review the 2018 to see if you want to use that, because you'd have really no documentation to base a decision on, because there won't be a 2015 to 2021.
Yeah, we had that issue with going from the 2006 to 2015, so, yeah. But I may have, see if I can get Jerry or Larry in here to say what the changes are to the NEC also, so we know what's going on there.
I think it would be worth the discussion.
Chairman?
Okay.
Yes, Stephen?
One last remark, or just thought to what Scott was saying. Isn't there an avenue as well that's almost a hybrid approach? So, for example, you and I talked about the 2021 building code now has an amendment in there for shipping container-based structures, right, in Chapter 31, where we could adopt the 2018 code, but then bring in small parts of the 2021 code for things that aren't addressed.
Yeah, I was going to look at that for shipping containers, since there is now a standard for that.
But
So-
I'm just using that as an example.
Yeah,
There
but
would
we
be
can
other
add that
technologies
to
as
the
well.
2018.
So that would be like a hybrid approach to what you're talking about, right, Scott?
Absolutely.
Yeah.
And I think just at least getting a better understanding of what's in the 2018 as it relates to the program.
Mhm.
And at the same, before we actually make whatever decision is to evaluate what's in that future code. So if in fact there's something that we want to pull from a future code and incorporate at this point in time, or if there's value in skipping the 2018 and also amending the 2021 code to be more relative to the 2018 and maybe some of those issues that may be problematic.
And if the-
I will tell you that I've also recognized there's been a lot of retroactivity in later editions of the code. So the retroactive provisions aren't necessarily beneficial, and a number of municipalities are amending the code not to have those retroactive provisions. So I just think that it's wise for us to evaluate both, certainly with a focus to Randy's point on that, understanding the difference between the current code that we're under, what the current published code is, and then what's the future hold. And so at least we have the knowledge base to make the best
Right.
decision.
And we could also, if we decide to skip the 2018, go 2021, we could adopt the 2018 energy code if that's a big issue. And I don't like to do that, but we could do it.
Sure, absolutely. And I don't specifically recall, and maybe Randy can help with this. I think there were some provisions written into the law when the 2015 was enacted and put the piece in there to the 2022 component, that it also restricted municipalities from So if in fact my city were to elect to adopt the 2018 energy code, they couldn't change the R factor of components, the prescriptive requirement in wall and ceiling. So I think the legislation also has some provisions in there that restricts municipalities from adopting the code straight up. But I can't be certain.
I don't remember that. I'll have to look at it, though, yeah. So, and what was the retroactive? What did you mean by retroactive?
There are retroactive provisions of the code which would apply less to the program, but could, I think, have an impact on the program, that existing buildings, certain things might have to happen which are more fire-related. So the retroactive provisions are just, again, another problematic way, and I don't want to say special interest groups, but special interest areas were having more of an impact, where energy and fire provisions ending up in the codes just created greater problems across the.
Okay.
So what's our next step?
I guess we do need to make a motion to start the process.
I think we do.
I'm sorry, need what?
She needs a motion to start.
We need a motion.
I'll make a recommendation that we initiate the process to evaluate 2018
I'll second
family
that.
codes in the 20 and 17 NEC.
Okay. We've got a motion and a second.
I'll second.
All in favor, say aye.
Aye.
Any opposed? Motion passed. Okay, we're moving on to item H, discussion and possible recommendation on the proposed amendments to existing rules, 16 Texas Administrative Code, Chapter 70. Welcome, Molly.
Thank you very much. Molly Fudel, Assistant General Counsel. I'm going to present the rules today on agenda item H. Donna Lipke's going to return, and she's going to correct me whenever I mess up. So these are the rules that are intended to implement two pieces of legislation from last session. One is HB 1385, which removed the height limitation for buildings and housing that fell under the program. The other is HB 2546, which allowed manufacturers and builders to construct single-family housing, industrialized housing, in accordance with certain amendments and alternative compliance paths. We also included some clarification and cleanup changes while we had the rules open. These were published in the Texas Register on November 29th, and the deadline for public comment was December 30th of 2019. We received comments from 3 people. I'll go ahead and go through the comments as they are in your packet of comments. And feel free to stop me at any time if you have any questions. So the first comment relates to the changes to 7073, requiring a final inspection after all construction and corrections are complete. Essentially, the commenter disagrees with the department's assessment of economic costs and believes that this, in the proposed rules, would create costs. However, this provision exists in the rules. We're just kind of moving it around to implement the new lack of height limitations. So we do not anticipate that it would, in fact, create any economic costs.
So you're saying to incorporate what the commenter's recommendation is, or not incorporate that?
Not incorporate. We don't believe that the commenter's concern about there being any probable economic costs to comply would actually happen, because this is an existing requirement.
I gotcha. Okay.
So the next comment has to do with the ICC certifications that the proposed rules require for personnel of the DRA, design review agency, third-party inspectors and inspection agencies and site inspectors. And this commenter states that manufacturers and builders routinely work with third-party companies to design and install and inspect the fire suppression systems. and that these companies may or may not have the ICC certifications. So the recommendation was to allow them to inspect, even though they may not have ICC certification. Talking with Donna, it seems like this comment is kind of talking about something else than what the proposed rules are talking about. Essentially, these rules relate to DRA personnel and third-party inspection agency personnel, not the people who work with or contract with the manufacturers in constructing the buildings or the builders in installing the buildings. So the rules would not prevent a manufacturer or a builder from working with these third parties.
And it seemed to be mostly related to sprinkler systems and the fact that Texas Department of Insurance has licensing requirements for that. They would still be required to meet those requirements, but the plan reviewers and the DRAs would have to have the fire plan reviewer certification. That's really for exiting firewalls, barriers, whatever, and openings that need to be protected. That's more about those things, not sprinkler systems. There is a certification for sprinkler systems, but we weren't requiring that. So that would fall, as far as I'm concerned, that would fall under TDI. So
You've just taken the word right out of my mouth. Yes, we as an industry, we as the IHB Council, I don't think we want to take on that responsibility. Those are in place. In most cases, to my experience, that's always handled on the local jurisdictional level. I know in the case in buildings that I've been involved with, we never put sprinkler systems in a building anyway. It all happens once it gets on site. So at the local jurisdiction, the local fire marshal can take his role and do that. The professional who designed the system is the person who's responsible on that end. That's totally isolated from the building that we are working on at our end.
yeah, we do have some instances where some of the piping is installed in the plant. We would look at that as part of the program, but the actual final completion of the system would be done on site and inspected by somebody who.
Testing and certification on site.
Yeah,
Yes,
by
absolutely.
whoever's approved by TDI to do that.
Right.
Donna, who's TDI?
Texas Department of Insurance, sorry about that.
Gotcha.
Fire Marshal's office is under that.
So we're not recommending any changes based on that comment. So the last comment actually contains several comments, and I'll go through them as they appear in the document. The first comment is on page 3, and it essentially relates to the National Electrical Code, the NEC. The commenter opposed the proposed rules, stating that only the National Fire Protection Association can amend the NEC, the department cannot. So the proposed rules supplement the National Electrical Code. Essentially what we do in these proposed rules, or what we're proposing, is to move a requirement for certain electrical testing from one section of the rules to another section of the rules. So this requirement already exists in the rules. We are just moving it and describing it in the rules rather than pointing to a section of the NEC. So even though we use the term amendment, but obviously we're not amending the actual document that is put out by the NFPA. This is a rule change that is within the council's authority and the commission's rulemaking authority.
Yeah, what we're changing was the council determined many years ago that these electrical tests should be done for all buildings manufactured. In the NEC, it's just requiring it for manufactured housing. So we're just putting in a section of the code that says manufactured buildings, where we're adding those test requirements for manufactured buildings, because we got some pushback from people saying, why do I have to do that? We're not manufactured housing. So that's basically the reason for that. So.
The rules are essentially designed to make everything easier to understand.
Yeah.
Okay. So I'll move on to the next one. Okay. So the next comment is similar to the previous comment, but it also states that legislation would be needed to supplement the NEC. The department disagrees. These rule changes are within the council's authority to issue instructions to ensure compliance with approved building plans, specifications, those kinds of things. It's also within the commission's rulemaking authority to adopt rules consistent with your instructions. So we do not believe that legislation is necessary to make this rule change. Okay, I will move on to the next one. The next comment is again about the NEC. We've already addressed it, so I'll move on to the next one. So the next comment disagrees with the department's local employment impact assessment. Essentially, the commenter believes the proposed rules will create additional requirements for builders, and the commenter also refers to comments at the end of the document about concern that equipment shelters are coming to Texas from overseas and are not being inspected pursuant to the IHB program requirements. So essentially, this comment is related to equipment shelters and, I believe, petrochemical facilities. There is no exemption in the IHB statute for equipment buildings or structures that are located on petrochemical facilities. So we do not have any authority to create an exemption. The council does not have the authority, the department doesn't, and the commission does not either. So therefore, we are not recommending any changes based on that comment.
Molly, so what you're saying is if they wanted this exemption, this would actually have to be a House bill, not something that this council would vote on?
House bill, Senate bill, some sort of legislation.
Right. The governor ultimately signs.
Right, and I'd also like to point out these electrical testing that's required, it's required for equipment buildings, it's required for all industrialized housing and buildings, as Donna was saying. And this is something that already exists in the rule. So it's not creating an additional requirement. All right, so I'll move on to the next comment. Let's see. The next one is again about the NEC, and we've addressed that. Okay. So the next comment relates to the clarification language about site inspections, whether site inspections are required. And there's an exception in the rules for certain buildings, and we've changed the language to try to clarify it. It's not intended as a substantive change. The comment is stating essentially that this is something that must be legislated. It's a piece of legislation. However, we disagree because we believe it is within the council's authority to issue instructions regarding inspections. Again, this relates directly to site inspections and to buildings that are within the IHB program statute. Okay, so I'll move on to the last page of the rules. There are several comments here. The first one is again about the National Electrical Code. The next two comments are also about the National Electrical Code, but they make additional points, so I'll go through there. Essentially, one of the comments relates to, states that the electrical tests that are required don't make sense for equipment shelters housing electrical equipment, that they might cause accidental damage and damage the equipment housed inside. However, these tests are required in the factory, and you want to say something?
It's required for the electrical system of the building. It's not, the equipment is not tested, it's not part of the test.
So it would be the test that occurs in the plant before the equipment is installed into the building.
They do install the equipment in the building, in the plant a lot of times, but it's not under our jurisdiction.
I see. So it's just the electrical for the structure itself.
Mhm.
I'd also note that this electrical testing is already required under the rules, and to my knowledge, we have not received any reports of accidents or damage.
Not that I'm aware of.
Okay.
No.
Okay, so I will move down to the next comment. It again talks about the authority of the IHB program to regulate equipment buildings and structures on petrochemical plants. There's also it also talks about the department's ability to regulate these and again, the concern about buildings that are coming in that are not being inspected under the department rules. Again, these are within the department statute, and we encourage anybody who has any information about buildings that are not being inspected or constructed in accordance with the IHB program statute and rules, please file a report with us. The TDLR website has a link at the very top that says report violations, and you can submit a complaint with any information that you have so that we can investigate it as fully as we can. So on the very last page, the comments that are printed out are some of the comments from the previous page, but the last one is a separate issue. And essentially, it is a request for a 6-month delay in approving the proposed rules. The department opposes this and any delay really because these proposed rules contain changes that are necessary to implement the legislation that was passed. And that legislation is already effective. It was effective September 1st. So any delay would cause a further lag time in our rules catching up with our statute. We believe it's important to go ahead and pass the rules. We also brought these proposed rules to 6 members of the council back in October, got feedback. You had an opportunity to provide feedback, and the public did as well during the 30-day comment period. So we do feel like there's been an adequate time for people to submit any concerns they might have.
So the intent is for discussion and recommendation, so it would be an item we would vote on, correct?
Correct. And so what the department is recommending is that you vote to recommend these rules, proposed rules, as published in the Texas Register with one minor change, and it's just a technical change. The rules were published with a letter missing in the very last rule. So in 70.101J, J2, there's B, and there's 2 Bs. There should be 2 Bs. The Texas Register published it with only 1 B, so we're asking that you recommend to publish it, or excuse me, to adopt it with that other B added back in. That's the only change.
Well, if I can step away from the agenda for a moment, one of the public comments has to do with this section and the revisions. And before there's additional discussion by council, I tend to think that it would be best for Mr. Guidry, did I pronounce your name correctly? Apologize if I didn't. Is it possible for him to address the council and talk about his position relative to the type of buildings they build? I think that would be of value.
It is. I would say for Open Meetings Act reasons, the discussion would need to be limited to the proposed rules and not wander outside of that, because all of the discussion on an agenda topic has to pertain to that topic. It can't go outside of it.
He could give some anecdotal information to groom his perspective of why it's important this way or that way.
Yes,
for
as
his
long as it
position,
relates
yes.
to the proposed rules, yes.
Understand.
Okay.
Would you give us an example of what would be considered wandering?
Mr. Chair, if I might, just.
Yes,
Would
Scott.
it be possible for staff just to monitor the conversation, and I'm asking that if we begin to wander or stray, that they go ahead and bring that to our attention? And I
That
think that would
works.
help rather than maybe what that explanation would be.
Absolutely, yes.
Thanks, Scott. Okay.
Thank you.
Mr. Chairman.
Thank you. Yes,
Doug Robinson.
I need a babysitter.
Since we have new council members, I just wanted to clarify that this is part of the Rule Amendment Committee that's been going on for over a year. And this is a cleanup where, as we've had different legislation over the last 10, 12 years, we've put stuff in different sections, and now that we have a better look at components and equipment shelters, this was a redraft where we moved stuff to the right section. We had duplication of language.
This right here is just for the bill implementation rules.
But we
But
did.
we did bring it to the committee though, so, yeah. And we are putting that into the rules that we're working on now.
Worked.
Yeah.
But for the most part, it's a cleanup. It's not a
Yeah.
change in
Other than the changes for the bill implementation, the other changes are cleanup, yes.
Mr. Chair?
Yes, sir.
One other question. If I have a minor edit or two or suggestion, is that possible at this point in time? Didn't ask you. You were
That's a
not the
Molly
chair.
question.
Yes, it is.
Thank you.
Thanks, Molly.
Mr. Guidry, if you would come forward, we'd appreciate it.
Through the chair.
Yes.
Stephen, we don't know if there's wondering until the wondering starts.
Roger that, sir.
Good afternoon. Thank you, Mr. Chair and TDLR staff and council members for letting me voice my concerns today. And before I go any further, please, Ms. Fidel, if I get out of lines, please just knock me off the chair, slide me upside the head. I'm used to it.
We have an escape hatch button right here.
Okay. My name is Eddie Guidry, and I'm here today with my supervisor, Mr. Sean McGaugh, back here in the audience. The reason that I'm here is to speak from a standpoint of codes and standards, which I am employed with Fluor Corporation, which is a large EPC, which is an engineering procurement construction firm that operates globally in 6 continents with approximately 50,000 employees. The bulk of our work is done in the petrochem sector, the energy and chemicals, which is where I got involved in this. I don't typically play in the buildings world as far as, that's why I'm late to the party as far as bringing these issues up and just until now, and I apologize for that. What's been happening is over the last few months is some of our vendors, some of our staff, some of our clients have noticed that things are being done in these and enforced in these buildings that are really not buildings. Yes, they do have a floor and a roof and walls, but people don't live in them. The construction is not combustible type materials. The wiring is open type wiring or construction. The wiring is actually concealed per definition in Article 100 of the National Electric Code because it has to be withdrawn to actually see the wire. But the conduit system and the tray systems that we use are considered open construction in these buildings. So you can, it's not like we have combustible materials like you would have in a trailer home, a mobile home, or an office building, where you can, those things are notorious for being flammable. I mean, they burn very easily. The structures we're talking about do not burn easily, if at all. And that's the key point here, of one of 4 or 5 that I'm going to make. But as far as the statute goes, the current law that I think has been misinterpreted for a while now, unbeknownst to me, until the last year, is the part where it talks about open construction. And it talks about also public buildings. Well, I've been talking with several folks here before the meeting, and I guess there's not really a definition anywhere that of what public is. I know it's being interpreted by TDLR staff that if people are involved, it's public.
I'll step in and speak on that. That's truly a term that is defined in the International Building Code and the suites of it, and that has caused some confusion, yes. Can't answer for the department, but it's not a definition that they just brought up. No, it's established.
Right. Okay, I'm sorry, I jumped ahead of myself. First of all, I want to thank TDLR staff and the things they do and are tasked with. Having been involved with, as an SME on the TDR electrical exams for the last 2 years with Mr. Gonzalez, they do an awesome job. And I'm not here, I think we're all on the same page. I just think that we're not aligned right now. And that's where the misunderstanding has come about. The bottom line is the petrochemical sector and our company for certain, that safety is the top pillar of our company. I mean, that is first and foremost what we do. And I think everybody in this room, otherwise, if they weren't interested in safety, they wouldn't be here. Having said that, I know that a lot of folks here, I don't know all of your backgrounds, but I know that most of you are not involved in petrochem, is that correct?
I am.
Okay, good. And there's some unique things about the petrochem world that don't apply like you would have in a building like this, or a home, or a mobile home, or even a temporary office construction trailer. There are the three types of buildings that I'm going to talk about today, and in your handouts, I have pictures. The first type is what we refer to commonly as a substation, or some people call them power distribution centers. What it is, these things are of modular type prefabricated construction, and there's many folks around the Gulf Coast for sure that make these buildings. And not only do some of them make the buildings, but they also are integrators, where they actually fab the building and shell, and then they install the equipment and hook all the interconnection wiring inside the building. The second type is an RAE building, control building, or instrument enclosure, goes by a lot of names, but typically there are computer systems and distributed control systems and instrument safety systems in there that actually control and shut down the plant if in the case of an emergency, or send things to flare if need be. That cannot be subject to any sort of damage. And what has happened, even though I heard earlier that there's not been any reported cases of this happening, I know of several that have occurred amongst the RIE builders where this third-party inspector came in, the wiring had already been done, and because there are no checkpoints or anything or anything established by TDLR of what needs to be checked and when and things like that, this third-party inspector, which is not TDLR staff, obviously, but he asked for this dielectric strength test, which is testing the insulation value of the 600-volt wire is what the intent is. And that's normal building wire like you would find in this building. He wanted to put this dielectric test. Actually, he imposed the test on the integrator to test the 300-volt insulated wire. Well, you don't put 1,000 volts on 300-volt insulation. It wasn't meant for that. And you certainly don't put 1,000 volts to electronic equipment. And this electronic equipment is what is the brains of the plant. It was, fortunately, in these 3 or 4 cases that I'm aware of, it was caught when it happened there at the integrator, but things like that can be damaged inadvertently and not know about it, and the building ships, and it be in service 6 weeks, 6 months, 6 years, and then it fails. This in turn can lead to a release. It can lead to an explosion. It can harm the community, and not only that, the personnel there within the plant. So that's where my comment came from, is that this, as well-intentioned as it might be to have this test, it was in fact, by the National Electric Code, only located in like trailer homes and office buildings that were combustible with construction closed with 600-volt wire in it, not these types of buildings that we're talking about. And so by doing this rule change or clarification, It's really not a clarification, in my opinion. We've taken what somebody thought was a good idea years ago, and it probably was at the time for whatever they were dealing with, and misapplying it to these buildings that really shouldn't be in IHB scope anyway, because they're not closed construction. They're not open to the public where you have like a shopping mall or a commercial building. The third type of building that we're talking about here is along the same lines, just a smaller version. It's an analyzer shelter. And there's a picture of that in your handout also. What these are is where you take hazardous gases and chemicals that are coming in, and basically you're sampling them to see for purity, for...
Mr. Guidry?
Yes.
Mary Winston is coming over here. I'm sorry to interrupt you. Mr. Chair? Mr. Brown?
Yes, I'm sorry.
Hi, I'm sorry. Could we take just a 5-minute break?
Absolutely.
Thank you.
Scott and I have already messed up the flow. You and I can have our conversation. We can take a 5-minute
Okay,
break.
if you'll
5
gavel
minutes.
us out.
Let's be back at 2:40, which gives us about 8 minutes. Thanks, guys. Thanks, everyone. We're back in session.
Should be okay.
Mr. Goodry, it's back to your floor.
Thank you, sir. I appreciate the break, actually, I really do. It allowed me to regroup, have a breather. On page 8 of your handouts, the slide that's called Current Issues is where I'd like to pick up. We've already talked a little bit about some of this. The first bullet point there being that these buildings are being shipped in by ports. Most of them come in by ports or rail with no inspection. Is that a reason for not complying with state law? No, it's not. That's, I'm not making an excuse there, but the problem is that is hurting our Texas guys, our manufacturers here in Texas, because they're inadvertently being penalized. Not only are these buildings of open construction and therefore exempt by 70.30 exceptions or exemptions, it clearly states that if it's open type construction, these buildings are not subjected to IHB law. And so here we are, that we have these buildings being subjected wrongly, in my opinion, to these tests and inspections. And the other part of that is now we have inspectors that, in my opinion, are not qualified to be looking at this sort of construction. The certifications for these inspectors, while IHB cannot do anything about that, I understand that. I hold these credentials, which there's not a lot to them. I could take anybody, non-electrical person, and spend 8 hours with them and let them pass the test, get them to pass the test. It's basic, just electrical stuff. It has nothing to do with what these buildings do. So the other part of it is the IHB laws are in conflict with the electrician's laws. The electrician's laws clearly state that electrical work inside of a plant or a petrochemical facility are not subjected to inspection, and the electricians don't have to be licensed. They did try to, a couple of years ago, they tried to make an industrial electrical license based on the National Electric Code, and that morphed into now you can have an industrial electrician license that's really not required because nobody's inspecting or enforcing it anyway with inside the plant. And it's not based on the National Electric Code anymore anyway. It's based on any CCR.
So, David Gonzalez, TDAR, we actually did develop the exam, but there's an alternative that we will accept that's through the NCCR that we also accept.
But the point being is that, the electrical law clearly understands that these petrochemical plants are not your normal commercial buildings with combustible construction. Even with inside the plant, these buildings are not accessed by normal personnel. It's strictly electricians and maintenance personnel that are qualified to go in there. And usually if you open up anything, you have to have a permit from the plant to open the piece of gear. The ICC and IECC there's a problem there because the ICC is referring to the IECC, which is Energy Code. And one of the problems there that's being enforced is automatic shutoff for lights within these buildings. And I guarantee you, I, as an electrician, would not want to be in one of these buildings and working for a couple of hours and risk having a sensor in that building not know that I'm there and turn out all the lights on me while I've got my hands in a hot piece of equipment. Granted, there are types of systems out there that use different technologies that they can put in that won't do that, but the bottom line is you don't want any kind of automatic override for the lights in that building. There's not that many lights in a small space anyway, so energy is it's secondary concern. Keeping that guy alive is the first concern. So the other part of it is with the IECC that's being enforced is the amount of lighting that's being put in these buildings. The Energy Conservation Code, and by their admission, there are no building types that are in the ICC that fit these structures. I've spoken many times with ICC in the past year, and right now, IHB is, I think, referring to them as type H, hazard buildings, but if you read the descriptions in the ICC, it doesn't apply. They're nowhere even close to being a hazardous building, as described in the ICC. So what's happening is these integrators are being told, well, because of ICC law, you can't put that many lights in here. Well, there's times when you're working in there and in a piece of equipment that is shaded anyway, that you want to have an overabundance of light around you. You shouldn't be restricted to the amount of light lumens that you can have. And that's what's happening. So, turning to page 9, the comments that Ms. Fidel referenced in a court about the NEC were mine. And I'm not here talking today just on behalf of my company, but as a citizen of the state of Texas, I would not want to live next to one of these plants knowing that part of the brains of that plant could have gotten zapped by 1,000 volts and damaged. It's already dangerous enough living near one of these places. The comments are the proposed changes that were posted online. I had a whole lot of heartburn with because they're inaccurate, they're misleading, and in some cases they're just downright incorrect. And I've noted that on your comments. There was Mr. Cuvion that apparently did an assessment and said that there are no anticipated economic costs to persons who are required to comply with the proposed rules. That is incorrect. You cannot take a rule like the testing that was required for mobile homes and impose it on this type of building without having an economic impact. And you can't enforce this rule on our Texas guys that are trying to comply with the law without enforcing it with the buildings coming in. So that's where I'm coming from as far as saying, in my opinion, yes.
Eddie, thanks for the analysis on this. I think Molly's covered a lot of what you're talking about here as far as the comments go, and I thought they were pretty well thought out. I just had a couple of questions as you're talking through this. We build a lot of these equipment enclosures as well. I'm a representative from industry.
Mm-hmm.
One of my questions is why do you have to go through the IHB on these types of buildings? Can't they be listed as equipment through like UL or some other certification?
That is an excellent point. And actually, that is an angle that I haven't approached, but you're absolutely right. There are large integrators in Texas that have UL listed buildings they're a system.
Yeah, we built several of those that have gone through that process.
And absolutely.
Donna's shaking her head.
And if that's the case, then, that puts a whole different spin on it. If it's a listed piece of equipment, then it says right there in the National Electric Code that if it's a listed piece of equipment, you're not required to have it inspected or torn apart or, as long as it's not modified, then it is what it is. And therefore, it should not be subjected to IHB rules.
Okay. Mr. Guidry, I'm sorry.
Yes.
It's not to rush you, but have you made all of your public comments?
Almost. Can I have about 2 or 3 more minutes to wrap up?
That is up to Mr. Brink.
That'll be fine.
All right.
Thank you, sir. The next thing that was stated out there is that there's not going to be an adverse effect on small businesses. Again, it does affect businesses, small and large. that integrate these integrators. The government growth impact, it says the proposed rules do not create a new regulation. To me, that's false, because now we've taken, and I understand better now as far as the amendment part, what they were trying to get across. It was stated wrong in the verbiage that was placed out there for comment. It said specifically that the changes are going to occur to the National Electric Code, which Ms. Fudel clarified that, and actually IHB is supplementing the NEC, not changing the NEC. So, but it does create new regulation as far as making these tests mandatory for these buildings. It says, the proposed rules do not increase or decrease the number of individuals subject to the rules' applicability. That too is false. It's just flat wrong. There are people being affected by this. The quantity, and the more rules you make, the more people that are affected. So with that, I would just like to kind of wrap up saying that I appreciate the time that you've taken to listen to me today. If there's any comments right now, I would be glad to take those. What I would like to personally walk away here today is to ask you to vote negative on the approval of the proposed changes based on what I've informed you today. And I would like to have at least 6 months to gather our clients and our integrators and our equipment builders to let them know what is coming down the pike, because we didn't have enough time. It took me by surprise, and when I've talked to them, our clients and our integrators, it took them by surprise as far as what was happening. And based on the fact that the statute is being misapplied, in my opinion, and the statements that were made for public comment, some of them are just misleading and flat wrong, then I think the public needs another shot to look at them again and digest them after they're corrected and the corrections are posted online. So with that, that's I appreciate it again. Thank you.
Okay. If you remain seated, I'll open it up for questions.
Chair,
from
Chair,
council. Yes, please.
I wanted to let you guys know of something that Mr. McDonald thankfully pointed out to me in the break. The document that was given to you has a couple errors on the last page of what was actually published in the Texas Register. I wanted you to know absolutely exactly what is published. On the last page, J2A, it says the wiring of, it says dielectric strength test, the wiring of each modular housing or building. That is actually what was published was the wiring of each modular house, building, or component shall be subjected to a 1 minute 900 volt dielectric strength test, and that's what we as a department are recommending. It goes on with all switches closed between live parts, including neutral conductor, and the house, building, or component ground. That's what was published. In B, on the second line, it says in the version that you have building or building component, it actually says house, building, or component is what was published to better cover what's covered by the IHB program.
Mr. Chair.
Yes, Scott.
Thank you for that clarity. That was where my confusion was earlier in the disruption. Another piece to that, and I think for staff, and specifically, and it might answer some of the opposition, and I will say, I think that as one of the fellow council members have mentioned, there are other options for you to pursue if you feel as if this is an issue. I think there's a misinterpretation, and even with the energy code, because again, the energy code doesn't necessarily apply to the lighting in that facility. That would be an exception in the energy code. So I think what you believe to be inaccurate isn't as inaccurate as you believe it is. I think it is interpretation, and of course, talking with staff, IHB staff, and where it is that we can make sure that inspectors are educated as to what they need to do. And I go specifically dielectric test, and I make the assumption that is between the building, it's within the building, it's not the equipment. So it is the structure, and there should be, and again, all switches closed. This should have nothing to do with any equipment installed, and that is separate from a building, even if it is shipped as an entirety. Is that an accurate statement?
Don, if you could come up to the front,
Yeah.
please. Pardon me, Mr. Chairman. We want to make sure that we capture this on the video.
Yes, Donna Lipke, Program Manager, IHB. Yes, that's correct. It's just the wiring of the building. It's not the equipment installed in the building. The procedures in the Compliance Control Manual of the manufacturer should specify exactly how that test is to be completed, and that equipment should not be included in the test.
So I think, at least from an IHB standpoint, that if we have to make sure that, whether we have to do some education with the inspections or publish something out, that where it is there may have been some instances to the past, the rules are not written that way. I'm not interpreting the rules that way.
No.
And the same with the lighting and the controls. So I'm gonna say that I'm in favor and going to support the rule changes. I do have a couple of minor questions that we can get to later. But I think that between staff and a better understanding of really how those rules are to be interpreted and enforced is very different than how I'm reading and understanding the rules, to your points.
Yeah, and I just wanted to make a comment too, that as far as UL listing the equipment, that's the equipment in the building, that's not the building itself. The building is not listed by the construction of that building.
Mary Winston, and I just not for technical expertise, because I do not have that at all, but we did, Mr. Guidry, thank you for your public comment, and he did properly fill out a public comment form. Public comment is given in these public meetings, and the questions that are asked are the questions like you, Mr. McDonald, that, the council has asked, clarifying questions as to, to make sure you understand what that public comment was, which you've done. And, but a conversation back and forth based on that public comment is not noticed, and we can't do that. So, he has given us a wonderful document, and he's been able to state his position, and you're clarifying what that is, but a back and forth, because it's not noticed, we don't do. Yes, sir.
Can I make a statement then? Or would that be considered
Announce
wandering?
yourself and make your statement, sir.
Okay, so Stephen Shang, sorry Eddie, we can't have a back and forth on this. So I just want to recap, I was pretty involved with House Bill 1385, worked with Representative King's office and then Senator Hancock's office as well. And I believe that these rule changes were meant for one purpose and really one primary purpose only, which is to remove the height restriction on modular buildings in Texas. We were one of 2 states in the country that had that, us and Louisiana, and I don't want to be grouped in the same category as Louisiana. So, we were the only 2 states in the country.
I
that
love
had
my
that.
home state, but I'll take that.
Sorry, I think LSU will still win.
Go Tigers.
But, that said, I think, the request for a 6-month delay and all that, I think it really throws things off because the legislature's passed something as well as the governor, and it was for that purpose. Now, if you want to talk offline about how we went about kind of looking at making an actual change in the laws in Texas as an option and all that, I'm happy to talk with you offline about that. But I think it is unfair to try to piggyback this kind of petrochemical point to just a simple rule change that says, okay, we're going to remove this height restriction. And that would just be my statement.
Okay, I'm sorry. We've kind of, you made your statement, and his statement is the foundation of the law that was just enacted. And you've stated your position, and you've also stated your position that you, Mr. Guidry, do not want this to move forward. So if we really kind of need to wrap up this agenda item, and you can talk offline if you would like. Well, hold on. I hate to take another break because that does break us off, but you're wanting to respond to that. I think we're okay right now, but we can all talk afterwards, or at least a non-quorum can talk afterwards. And,
I would like it to be a matter of public record.
okay. Is this just your further public comment?
No, ma'am.
Okay.
It's actually in response to what Ms. Lipke said. They do produce UL buildings that actually are UL certified as a building, not just the material in them. So
Mr. Chair?
that is incorrect.
Okay.
If I can make and I don't know if I can make a motion at this point in time. I understand that, and absolutely that you have alternate and means to go. I would make a motion to approve that if we're able to continue to discuss within that, the rules as proposed.
We need to keep the agenda to the motion.
So Mr. McDonald has proposed that we accept the amended rules as written, as modified, but have further conversations, if you will, relative on this issue.
If there's a second, I may have one other comment a question that I have related to it, but.
Okay, all right. Do we have a second?
I will second.
We have a second. We're open for discussion.
I just have a question related to, we have provisions in here for an ICC Fire Inspector 1 and an ICC Fire Inspector 2, Plans Examiner 2. I would only ask that we would include into that NFPA or ICC. I think it's more prevalent for NFPA fire inspectors, and ICC will reciprocate a NFPA inspector, so I think it's just more appropriate that we acknowledge both of those certifications.
Can we make that change?
You're asking to amend the rules.
Amend the language where referenced an NFPA or an ICC inspector and include NFPA, ICC or NFPA.
You're going to amend your motion.
I will amend my motion to include that. It was really a point of discussion if anybody had any heartburn with making that change.
Can I ask Molly Fudel, Assistant General Counsel, just to clarify, we talk about fire inspector 1s and 2s in a few of the rules. Are you talking about in all of these rules changing it?
In any location that an ICC fire inspector 1 or 2 is referenced, that would also include an NFPA fire inspector 1 or 2.
Okay.
And is that for plans examiner also, or do they have that?
I'm not aware of that.
Okay.
Is that substantially similar to the ICC?
I think
fire
it would be
inspector?
because as he said, that ICC recognizes that.
Okay.
It is actually more challenging for the NFPA. In most, I am an NFPA fire inspector, and ICC reciprocate, so I didn't actually have to take the ICC test because I am NFPA.
Okay.
Conversely, NFPA will not accept an ICC, so it isn't a change. It just really, I think, from a technical standpoint, that we'll probably have more people with an NFPA fire inspector, and then we're saying they're not qualified because they don't have an ICC, but actually it's a more stringent
Okay.
certification.
Okay.
So it includes both.
Okay. Thank you.
Second. Any additional discussion? All in favor say aye.
Aye.
All opposed? Ayes have it.
Mr. Chairman, just point of clarification, the vote just taken was for the amended motion.
That is correct.
Okay, so we still have the motion now on the floor that's amended.
Good point. Okay,
So
so,
now-
The original
So now we have to have a
motion.
vote on the motion that was presented
So
first,
that
that's
would-
now been amended.
as far as how item H is written, the acceptance of those cleanup changes that were put forth on their own. Yes, Doug?
That was approved.
By adopting that amendment, do we now have to publish the rules for 6 months?
No, Molly Fudel, Assistant General Counsel. Based on what Mr. McDonald is saying about somebody being able to get the NFPA certification somebody being able to get ICC if they have NFPA,
Correct.
I think that is substantially similar to what was published.
Okay, I'm open for a motion on.
Mr. Chairman, you have a motion on the floor.
Do we do?
You do have a
Still
motion.
active? Okay.
I'll second.
We got a second from Mr. Childers.
I
All
think
in
I
favor?
believe
Doug.
the second came from Doug.
From Doug.
Doug
Yeah.
is
Doug
the
second.
original motion.
Okay. So Scott's original motion is Doug's the second? Okay. All in favor, say aye.
Aye.
All opposed? Ayes have it. Mr. Goodry, thank you very much.
Thank you.
Thank you, Donna. So you're up next, right?
Yep.
Item I, update on the rule review process, including possible amendments to 16 Texas Administrative Code, Chapter 70.
I don't really have a lot to report on that. We have incorporated these changes into what we're doing for the rule review process. We are continuing to work on the rules. We'll be bringing more back to the work group in the future, hopefully the near future. And I would hope to see something for the council to look at their next meeting, I hope, because I do want to retire.
I understand. Item J, discussion and possible action regarding approval of third-party inspectors, third-party inspection agencies, third-party site inspectors, and design review agencies. Do we have a list?
We have 7 third-party inspectors and 1 third-party site inspector that requires final approval by the council. They've been found to meet the requirements in the law and rules.
Council, any discussion? Do I have a motion to accept?
I will move to approve the third-party inspectors and third-party site inspectors.
Doug Robinson has put out a motion. Do I have a second?
Second.
Second from Stephen Shang. All in favor, say aye.
Aye.
All opposed? It passed. Thank you. We move on to item K, election of new chair and vice chair. So the floor is open for nominees for chair.
Chair, Randy Childers. So just so the board knows and staff, in 22 days, I am retiring from my employment with the city of Waco after 32 years. So I will not be back unless the governor requires me to be back. Therefore, I will also relinquish my vice chair spot that I currently have and will not become the chair if a board member potentially appoints me to that. I will respectfully decline.
Thank you, Randy. Congratulations. You started working when you were 12 years old.
Pretty much, pretty much.
Okay, the floor is open for recommendations for chair.
I choose Roland.
I'm gonna
And I
retire.
move it.
He didn't talk, I second.
Do we have a second?
Second.
All in favor?
Aye.
All opposed? Okay, vice chair.
I'm not gonna be.
Dub has recommended Doug Robinson, has nominated Doug.
I may not be here.
When is your term out?
19.
In fairness, Dub, that would be 2 of us from industry. I think it should be somebody other than industry. So, but I
will lob it
appreciate
to
that.
Scott.
Doug would have been a good one. Do we?
I would second the nomination for Scott.
He's our guy.
Just-
Who nominated Doug and Stephen second? All in favor?
Aye.
Randy's executive assistant has been promoted.
Make nomination for an executive assistant?
Yes. Yes, Janet could be a good one.
No, Randy.
Randy, oh.
He
Just,
still has to serve
You
at
have to
leisure
find
of
him.
the governor.
just so you know, the governor's office is looking at appointments right now for this council. He's got some building officials to replace the ones like Randy, and he's got some industry contacts. He's still looking for site builders, though.
And per the governor's appointment office, this is my last year. They will not let me back.
Yeah, the laws changed that you can only serve on a board for 10 years.
Yeah, and it's been over 10 years for me now, so it's all good. All good. Okay, thank you, guys. Moving on, recommendations for the next council meeting, or recommendations for the agenda items for the next council meeting.
Are we able to have one January 30th?
There's not time to post. The wheels of government move slowly sometimes. There's not time to post for another meeting.
That was just for Mr. Childers. And I guess this question's for staff. So really, the next steps for staff on the codes, you would be prepared at what point in time?
Actually, I need to talk to ICC, to Hamid, and see if he can make a presentation and maybe get some recommendations from you, somebody else that might be able to present changes to the council.
Kelly Sadler is the government relations
Okay.
manager for Texas, Louisiana, Oklahoma. I don't know what all areas she has now. She's actually located here in Austin.
Okay.
As well, and that is actually her role, and speaking for her, she'd be happy to come attend.
Okay,
So
I'll
if we need to coordinate with her on the date, if maybe
We
that's the
probably will,
driver, and
yeah.
then maybe you can just put a survey out. Whether that's I guess was if we were gonna do this in the next quarter.
It's up to you guys.
I'd hate to have a meeting any further away than June.
Okay. We'll see what we can come up with. I'll get the contact information from you after the meeting.
Absolutely.
Because I'm afraid if we don't have it by then, time starts passing by so much that I would have to start
Mhm.
agreeing with Scott about skipping a code edition. which I
Right.
do not want to
That's
do.
why I wanted to bring it up at the last meeting.
Yeah, I agree. Mr. Chair, for the record, you don't want to agree with Scott, or you don't want to skip an edition?
We will
Mr.
send
Chair.
out some possible dates for you, Chairman, to be able to look at a meeting by June.
That would be very good. Yes,
Mr.
If I can offer an agenda item, I know Kelly on staff actually sits on an ANSI committee for kind of the ICC that's looking at kind of modular codes across the country. It might be informational for us as a council just to get a briefing on kind of what's transpired up to whenever we have the next meeting, as I know that's a big effort nationwide.
Yeah, I think that's a great idea. And Kelly, we appreciate you jumping in and volunteering and being part of that. Is that okay with you that we put you on the spot? Okay.
Mr. Chair?
Yes, sir.
If I might just have the floor, I'd like to acknowledge Mr. Childers and his service to the board.
Thank you.
He's
Yes.
been on here for far too long, I think, and his attitude shows. But certainly we appreciate the fact that his attempt at providing good service to Texas is warranted.
Yeah,
Accolades.
we will miss him.
Yes,
So.
we will.
David Gonzalez, TDLR. I would also like to echo those sentiments. Definitely appreciate the work. There's lots of hard work that goes into this, including all the code review committee things. So thank you for your years of service, because it is a well-paid job, I know.
That's what I think I'm missing the most.
Thank you.
We're gonna double his pay in retirement, so, and for those that need it, I'll have his personal email address, so if we need additional service, I'm certain he'll help.
Okay. I echo, I repeat those remarks. Thank you very much. It's been a nice association. Okay, so Mike, you're going to put together a list of possible dates. So we've taken that off the list.
I will reach out to you for possible dates.
That works. Thanks to everyone for showing up. It's good to have a quorum so we can get things done. It's very much appreciated. And with that, do I have a motion that we adjourn?
Motion to adjourn.
And
Second.
Everybody else can second. Thanks.
Second.
Thank you, guys.